There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Hello. You're welcome to today's edition of Hanging Out with BWF Solicitors. I hope you are all doing very well. I am Vicky Newton, your host for today's show. One might be asking, themselves, if you've been given your visa or you've been given your leave to remain, and you decide to travel, from one country to the other, or probably traveling on holiday back to the UK, you will not even think, you'll be stopped to be asked certain questions. Such questions may include information you provided during your, application, because you believe that all the information you provided, were vetted and approved, and also through that you've been given your leave to remain. So there's no point being asked those questions again when you're traveling into the UK. But yes, Laura Eunice is here today to tell us that might not be the case. It's not every person who arrives at the airport is being interrogated or being asked questions, how he or she got her leave to remain in the country. But you might be unlucky and picked to be asked those questions. And when that happens, we realize that some people are found wanting. So today's topic is, can one's leave to enter the country be cancelled at the airport if it is suspected that false information provided as part of the application? With me today is lawyer Eunice Achampong, a partner of BWF Solicitors, a mother of 2 beautiful kids, and a wife. Lawyer Eunice, you are welcome to today's edition of Hanging Out with BWF Solicitors.
Thank you so much, Vicky. I hope you and the family are also doing well.
We are doing very, 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 very well. We are doing
today.
Very well.
My hair and your shirts are matching.
I think we have to swap. I was asking myself what's going on. I think if I have your hair extension, I think that will complete the look, because the lipstick and the shirt complements. Yeah, but
of course,
such is life. We can't have everything 100%.
But
anyway,
I like
you look very well.
Yeah, it's great. I'm loving it.
Good.
And it's sunny weather outside as well.
Exactly.
I think for Londoners, we are enjoying a good sunny weather as well. Yeah.
Oh, that's great. Ladies and gentlemen, I would also like to inform you as well that BWF Solicitors is one of the top 3 family law solicitors in London. Some of their specialities are family law, immigration and nationality, Ghana law and practice, dispute resolution, and many more. So, Lawyer Eunice, being a partner of BWF Solicitors, coming our way today, leaving all her busy schedules behind to come and educate us and tell us what we should do and not to do to, be at the wrong side of the law. We really appreciate you, Lawyer Eunice, for, coming our way today, to give us more information on this topic and also advise us on the do's and don'ts. Lawyer Eunice will also be giving us some of the, news flash that happened last week or maybe probably 2 weeks ago. And she'll be able to update us on all those information. I know that some of you are not abreast with what is happening in regards to immigration. So today, Lawyer Eunice is going to keep you up to speed of what is going on in regards to, immigration. If you want to contribute to this program, you can do so on our Facebook and YouTube handles at BWF Solicitors and Vicky Newton. If you want to call us directly on this show, of course, you can do that on 0744 8619 711. The number again is 0744 8619 711. Those who prefer to send me a WhatsApp message, of course, you can send me your questions on the WhatsApp number 0744 8619 711. So, Lawyer Eunice, back to you. Yes. So, what is, keep us updated on what has happened in regards to immigration. For me, my highlight was, the news about bringing your dependents if you are here to pursue, your postgraduate, education. And honestly, it was a big blow because a lot of people, got their stay through coming here as students. So how can you, come here to study and not have your dependents with you? Is that not a breach of human rights? But
yeah,
I'm not going to go into that. You start where you want to start, but make sure that you hit on that one as well because it's very dear to me.
Definitely. I think that obviously the thing about our lawmakers is that they are also politicians and they have to move with the people's views. So
Right.
as much as we are saying that the laws are in place to be upheld, the politicians are also people that have been put in place by the people or the majority. So they will obviously go with the views of the majority sometimes. And as you were saying, it has been in the news this past week about dependence of students not being able to come and join them here in the UK.
Yeah.
So postgraduate students or students who have studied a master's degree or let's say are studying a doctorate degree, usually the course will be for about 2 years unless obviously the course is a very long course which involves a lot of research. So they're saying, do you know what? The numbers are increasing. We want to now curb the numbers. And the only way we can curb the numbers is if we prevent family members of students coming to join them here in the UK. Obviously, this is something that should have been looked at in hindsight. And then we have the migration team that obviously advises the government in terms of their policies and what they need to include in terms of their immigration rules and laws and the such. So when it comes specifically to family members, like you said, human rights come to play because we all know that under Article 8 of our European Convention on Human Rights, a person has a right to family life and to private life. But because it's not an absolute right, the government can, of course, say that they can limit those rights in certain circumstances. And some of those circumstances include that if it is against public policy or against public safety or against public security, then of course they would limit that right.
Right.
And they're saying that it's against their policy because they feel that immigration numbers are increasing and therefore they should have the right to limit it. We will see how that argument will be put across in a test case if somebody were to go ahead and have a judicial review done, because obviously most people who come on a student visa don't necessarily have a right of appeal.
Okay.
So you are given the option of administrative review, or you are given the option where you can say to the caseworker who was working on it to reconsider that case because obviously they didn't make the right decision, so on and so forth. But if you feel that your views have not been paid particular attention to and you don't want the Home Office to come back with the same response, then you may have to look at judicial review. And if it is a case that you have a strong argument why your family members, which are your children and your spouse, should be able to join you here in the UK, then you put your case across. And so it is not retrospective. So what they are saying is that for the coming months, they're going to then have it put in place. So nothing is effective at the moment. Those that are here with their family members are not going to be affected in any way. And they're looking to see that if they were in future to allow students to come, then they would not allow them to come with their family members. But we would see how that will pan out in terms of future applications where people would want their family members to join them here in the UK. Yeah.
Okay. All right. Because I'm of the belief for so many years that if we look at those who have added financially to the economy, it's foreign students because they pay foreign fees. And I believe their dependents also occupy the health sector as well. About 90% of their dependents occupy the health sector. So honestly, I don't know. The only downside I might think of, which will be an issue, is they are going on the healthcare service free of charge, and I think they can also go on benefits, some of them, isn't it?
Yes. So in terms of
I think that is the downside.
With students in particular, especially because the economy benefits so much. I was reading an article the last time, and it says that students in themselves contribute millions and millions of pounds into the British economy. So we're not just talking about thousands, we're talking about millions, maybe more than £1 billion pounds into the British economy every year. So it is not to be taken lightly. They contribute so much into the British economy that if they were to say that they were going to stop students from coming into the UK to study, I think it will have a detrimental effect. So that's why I said it would be better if we look at the test case. So if, for instance, a student was coming and he was going to bring his family member, like his wife or his child or his children, and he was told, unfortunately, you can't bring them along, would that prevent them from coming to study in the UK, or would that actually still make them want to come and study here in the UK? So there are those arguments. And even though most students who study to work within the NHS, such as doctors and nurses, may have their tuition fees paid for them by the government. It is not applicable to international students. So they don't benefit from that side of things when it comes to them working within the NHS. They may be working within the NHS, but they are only allowed a specific period of time. Yes, students are allowed 20 hours per week, but because we are in demand when it comes to the health sector, they may work a few more hours just because that area is in demand, but they don't necessarily benefit from the UK economy in any way, shape, or form, because at the end of the day, they are working to earn a living or to earn an income. It's not as if they are just sitting down for somebody to feed them or to give them some cash handouts. So we are still saying that the UK economy is benefiting a lot from the influx, or should I say the income of the people that are coming here as students. If they were not paying the fees, if they were not maintaining themselves by paying the rent, going shopping, doing all those things that they do, then of course we wouldn't benefit so much from the students that are coming from outside the UK. Yes.
All right. Well noted. All right. So
yes. So I'll go ahead with the with other updates as well. So I was also going to mention the fact that when it comes to our long residence applications, generally we know that when you are saying that somebody has lived here for a period of at least 10 years lawfully, they can make an application for indefinite leave to remain. So this is not the 20-year leave to remain application where you can say that you've resided here for a period of at least 20 years. This is long residence based on 10 years lawful residence in the UK. So when we say that you are making an application for long residence under the 10-year route, it is to do with the fact that you are able to show that you have lived here continuously for a period of 10 years on a lawful basis. So students, for instance, who have studied here in the UK for a period of 10 years or more are able to apply for indefinite leave to remain, even though the student route itself does not allow for indefinite leave to remain. So it's good that at least there is that leeway for those who have lived here as students. And of course, if you are making that application, there has been amendments because the government introduced their new guidance last week to show that if they are looking to see how this is calculated, they will not include any period of time in which you came here as a visitor. So it may be that somebody came here as a visitor, they went back to their country as usual, they came back again with a student visa, maybe they went back again and then they came back with a student visa again. It could be that whilst they were here in the UK, they switched to the partner route because they met somebody here and they decided to get married to them. And they've obviously accumulated a lawful period of 10 years. So the government is saying, no longer would we consider a period where you know that you were not supposed to come and settle here in the UK. So if you were a visitor, we will not consider that leave which you had to come into the UK as part of your lawful residence. We will not also consider maybe a person who may have come here as a domestic worker. So if you came as a domestic worker, we would not consider the leave that was granted within that category. We will not also consider somebody who came here as a short-term study student. So if you came here to study for a period of less than 12 months, we will not consider that leave that you had as a short-term study visitor to count towards your lawful residence. And if, for instance, you also say that you came here as a parent of a child student, they're saying we will also not count that towards your general lawful residence. So it's good to look at what they will consider as counting towards your lawful residence. So, like I said, if you came here and you switched routes, as long as you switched within your time limits. So, I'm not talking about somebody who waited until their leave expired and then had to now reapply. So, you applied whilst you still had leave or whilst your leave was extant. You reapplied for, let's say, a parent route application because maybe you found someone here, you had a child with that person, and now
Mhm.
you have a British child, for instance, and therefore you are relying or you relied on the British child in order to get your leave to remain here in the UK. Yes, they will consider such leave, or if you came here as a skilled worker, yes, they will consider such leave. Or, as I mentioned before, as a student and you've accumulated 10 years lawful residence, they will consider such leave. So, if for any reason there are any gaps, so you are saying that you were not able to make an application in time, if your application was made within 14 days of your leave expiring and you have reasonable excuse why your application was not made in time, then they may be able to consider those reasons and then say that because you gave those reasonable reasons, we will consider that your leave was not made with gap. So, those of us who, for one reason or the other, may have had valid leave, it expired, and then later we went and we made an application, we were granted. If the leave that you had expired and it was more than 14 days before
Mm.
you made your next application, then please note that it may be that there is a break in your lawful residence and they may not consider it as continuous. So
Okay.
that is also something that should be noted. And it goes without saying, if you had spent any time in conviction, if you were also convicted of a crime which went together with a prison sentence, whether it's 6 months or more, those times will not count towards your lawful residence. So, any form of criminality which involved conviction would definitely not count towards your lawful residence. And it's good to bear those ideas, or should I say, those things in mind when, um, especially our young people, are making applications under the
Mhm.
lawful
Mm.
resident, because I know there are also those people who came here as child students who also look forward to applying for lawful residence afterwards. And it's good to also know that they look at your absences. So you shouldn't have been absent from the UK within that period for a
Good.
period more than 450 days. So if for any reason you have been absent for more than that period, then note that it will be very, very difficult for them to also grant you indefinitely to remain, because you've been so absent from the UK that it seems that it is not your home and you are not going to make it your home. So
Your home.
yes, they want to make sure that you are making the UK your home. So that is in regards to our long residence application. And then, secondly, I wanted to touch on the biometric cards. A lot of
Mm.
people say that they have now realized that their leave to remain is extended to a certain time, and then their biometric card ends in December 2024. There's a reason for that. So, if you have been granted leave to remain and your biometric card states on there that, let's say, my leave is valid from 27th of May 2023 to 31st December 2024,
Oh,
because your leave is now stated clearly on your letter. So you
right.
know that on the letter that you were granted leave, it states that your leave is supposed to start from 27th May 2023 and it will end, let's say, in February of 2025. But because your card says 31st December 2024, you think there's a mistake and you want to clarify that. It is not a mistake. It is because they want to digitize everything by the end of 2024. So they will want using biometric cards in its entirety. So if you know that you have a biometric card that ends in 2024 or even later, by which time they intend to stop using biometric cards, know that everything will be electronic or will be digitized. So even if you were to travel and come back to the UK, everything will be on their system. They wouldn't necessarily need your card to be able to verify whether you have leave to remain or not. Because
Laura Eunice, so are they going to scan our eyes and fingers and things like that?
well, I believe that time will come back. It hasn't yet. It hasn't yet.
It's going to be a problem.
I know, right? At the moment, some passports have biometrics in them, and I know that we've moved towards that stage because they want to be able to scan passports and then obviously record who is coming in and who's coming
in and out. Yeah.
Yes. So I believe that even if the passports are scanned, as soon as you get to, let's say, the attendant at the gate, he's going to look up your information because it's already been scanned to them, and then they have information brought to them. So even if it's not the biometric card, they can still have your information brought up onto their system as soon as possible. And so I believe that is probably the reason for biometric cards, because they do take your photograph and they do take your fingerprint and they put it on there. So I don't think they will be wasting too much money scanning people's eyes and faces, unless maybe I'm wrong and they have that amount of money to be wasted, which I believe is not so. So the passports will be the main means by which they will be taking that digital information and then getting it put on their system, who is who and who is coming through the airport. So when it comes to digitizing everything, I think the technology is there, the systems are in place. I know in other countries they've already started using these mechanisms. People say that Britain is very much traditional, so we take time to introduce certain things within our systems. But I think that it will make it crucial for them to collect information much quicker and much easier, unless obviously a person is not coming through the airports, then obviously they wouldn't have that information, or they wouldn't have those information readily at hand. So yes, biometric cards ending on the 31st of December 2024 is just for the government to introduce digital way of holding information. A lot of people will now have to provide share codes for employment, for renting, and other things. So it's also a new way of them saying everything is on the system. You don't need to physically show your employer or landlord anything. They will just go into the system and they will be able to view whether you have the right to work or the right to rent and so on and so forth. So I guess we are going into a very digital age. So
yes, better get used to it.
Yes, those who are not used to it need to get used to it. And I know some people are very much old school. They will still want something printed. They will want to show something. So, well, if you have your letter that granted you leave available, you can always do so. So that is something else to bear in mind as well. And last but not least, I'll just briefly mention the fact that when it comes to our EU applications, whether you are a family member to an EU national or you have decided that you are coming here as a dependent of an EU national,
Yeah.
please, the applications under the EU settlement scheme are for those who became family members before 31st December 2020. So if you make an application and because you believe that you're an EU national, you can make such an application. Make sure that if you're bringing a family member to join you, or if you have a family member here who is already with you in the UK, that person can show that they were a wife or a husband or a child or a grandchild or a parent before 31st December 2020. Otherwise, it may be that you may have to come under the immigration rules to
Mm.
make the application. And under the immigration rules, there are application fees to be paid. It is not free, and you just have to prepare yourselves to pay those fees because that person became your family member after the 31st of December 2020. So I'll leave the updates there. And
Wow, that's a very lengthy update. Wow, it's all good. So, ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors with your host, Vicky Newton. My guest is a seasoned solicitor of BWF Solicitors. She's also a partner at BWF Solicitors. She's here with us to discuss the topic: can one's leave to enter be cancelled at the airport if it is suspected that false information was provided as part of their initial application? So Lawyer Eunice is here with us, taking us through this topic, what we should do, what we shouldn't do. If you want to contribute to this program, I would love to hear from you. You can do so on our social media handles at BWF Solicitors or Vicky Newton. You can also send in your questions to our WhatsApp number, which is on your screen, 0744 8619711. The number again is 0744 8619711. Of course, you can also send me WhatsApp messages. I think this is the most popular means of people communicating. So you can also use that medium to send me your questions on the same WhatsApp number, 0744 8619711. So back to Lawyer Eunice. Lawyer Eunice, so what are the mandatory reasons for refusal under the immigration rules in regards to this topic?
yes, so this topic is one of those topics where when people come in and they are in trouble, they always want to seek legal advice and see how best they can get themselves out of such situations. So, when we talk about somebody coming into the UK, most people are happy the moment they receive their passport and there's a vignette saying you have been granted leave to come to the UK, whether it's a student or a dependent or a visitor or a skilled worker or a parent or a partner. Anybody who is coming on whichever route you are applying to come on, you are so excited, you are so happy, you are super excited that you are getting the chance to move from your country to the UK. So you don't want anything like this to just spoil your happiness or your mood. And I've realized that it is now become very common. It's no longer the case where okay, it will be smooth sailing as soon as you get to the airport. You just pick your bags and you're off, you're gone. like we were saying during the updates, the numbers have increased in terms of immigration. So the government is now looking at ways to curb the numbers. And so any way they can refuse people's applications, they will try. But don't fall victim to all of these things that are going on. So we are here to educate and to make people aware that it is right that you are also informed as to how these things can happen and how best to make sure that you don't fall victim to them.
Yeah.
So yes, you are, let's say that you've come here as a visitor, you've been granted leave of 6 months, you've come to visit the UK, you get to the airport, they say to you, okay, so who are you here to visit? We want to know what this person you are coming to visit does. How are you going to maintain yourself? Are you going to be looked after by this person, or you actually have some money on you? If you have some money on you, how much do you have on you? How long do you intend to stay? Have you previously been to the UK before? Are you somebody who has traveled elsewhere? So they can ask you various questions just to verify the information that you gave when you were making your application to come to the UK. Unfortunately, it is the case that sometimes our people may allow other people to make the applications without them having copies of it.
Yeah.
So it may be that an agent made the application, they have no clue what information was put on there. Even if you ask them what documents were used, some of them will tell you they don't have a clue what documents were used during the application. And so that becomes an issue. And then you become stuck when you're asked these questions. But let's look at our immigration rules. What does the immigration rules say about refusing or cancelling somebody's entry into the UK? So yes, you've been given leave to enter, but when you get to the airport, they can still say that they are refusing you entry into the UK for different reasons. And so I'll divide it into two parts. We have the mandatory reasons why they should refuse you entry or refuse your application. And then we have the discretionary reasons. Yeah. So it makes it very, very important that we adhere to those two reasons why they may want to, of course, refuse a person from entering here into the UK. And it's important as well that we keep abreast with what is happening, because at the end of the day, if you are saying to yourself that you are making an application, you get it, and you are returned back to your country, then what was the point of you struggling to make the application in the first place? Yeah.
Wonderful. Wonderful. So, Eunice, can one be detained if it is suspected the information given is false?
So it is likely that a person can be detained. And the reason being is when the Home Office or the Border Force agent, so the Home Office has different departments within it. So you have the UKVI, which is the United Kingdom Visas and Immigration section.
Yeah.
Then you have the Border Force, which is those people that you meet at the airport. Hello.
Hello, Oli. All right, ladies and gentlemen, I think we'll go for a short break with a promo advert from BWF Solicitors. Just for little Oli to settle a little bit. You know, this is a family program, so there's nothing wrong with our little Oli joining in this.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome back to this program, Hanging Out with BWF Solicitors. Before we went on this break, if you've just joined us, we were talking about the topic, can one leave to enter be cancelled at the airport if it is suspected that you provided false information as part of your application? So Lawyer Eunice was taking us through the two reasons for refusal under the immigration rules, which were mandatory reasons and discretionary reasons. So we'll just continue from there. But before then, I'd also like to remind all of you watching us, don't just watch us. I believe you've also had your fair share of experiences, or you might have heard someone, sharing their experiences when, they had certain issues when entering the country through the airport. So we'd love to hear from you. You can do so on all our social media handles, Facebook, YouTube, at BWF Solicitors and Vicky Newton. If you'd like to call us in the studio, of course, I just want my phone to be, so busy with phone calls. Please do call me and contribute to this program. You can also text me on WhatsApp with your questions, and Lawyer Eunice will be very happy to pick that up and answer those questions. The number to call is 0744 8619 711. 0744 8619 711. Lawyer Eunice.
Hiya. Sorry about that.
That's fine. That's fine.
So I was talking about the fact that, of course, it is possible that a person may be able to be detained. And as we were talking about mandatory reasons and discretionary reasons, it can come to their attention. For instance, if somebody has committed a criminal offense for which they've received a conviction of at least 12 months, that if this is the case, then they will obviously refuse that person's entry into the UK. So usually matters of criminal issue where, for instance, the person has been convicted or there has been previous exclusion order or a deportation order, those reasons are mandatory reasons. So those reasons are going to force the officer to definitely refuse you entry and put you on the next plane back to where you came from. When it comes to discretionary reasons, yes, there may be reasons such as you haven't come into the UK and you may have breached certain immigration rules or laws. So, for instance, you came into the UK and you basically overstayed your leave in the UK, and for one or two reasons, you decided to come back again. if it is on their systems that you are somebody who previously entered the UK and there are specific periods of ban which are applicable to people who may have come into the UK and overstayed and want to return into the UK. So, for instance, if I came here and I overstayed and I went back, usually they will give me a 1 year automatic ban if I voluntarily left the UK. But if it came to their attention and they removed me, and obviously they removed me because it was an issue, it could be that they will give me 2 years ban, or if I went with the public expense being paid for, so they paid for my plane fare, they paid for the things that I would need when I go back home, then it may be that a 5 year ban will be applicable. So of course, if they seem to think that you have breached certain immigration rules, they may cancel your leave to enter if that period of ban has not been adhered to. So, if, for instance, I came into the UK, I went away, I used NHS, I did not pay for NHS, definitely they may also refuse entry into the UK because I owe the NHS some monies in terms of treatment I received or whatever it is. It could also be that I came into the UK, I committed certain offenses. It may not have been prisonable offenses, but I was seen to be some sort of a persistent offender in one way or the other. And they don't believe that my behavior is conducive to the public good. So they may say, do you know what? We don't like the kind of person that you were, so we don't want you in the country in the first place. So that could be another reason where they may also refuse you entry into the UK. And then we come to what this main topic is about. If you have provided false information or they believe that you use deception in gaining your leave to remain into the UK. So if for any reason you have provided them with information whilst they're questioning you, and the information doesn't tally with the information you gave during your application, they obviously will grow suspicious of the fact that you are not a credible person because the information you have given is not tallying with the information they have on their system. And therefore, they think that you are somebody who is not genuine, who is not trustworthy. It may be that they will be thinking there might be some evidence of deception, and therefore they do not want you to remain here in the UK. And if they have clear evidence, so for instance, you go to the airport, you have a whole load of documents with you, you have some bank statements, you have birth certificate, you've got some few documents with you, and they go through your things and they pick up on some of these things and they look at the information on there and they verify with their scanned documents. So now everything is scanned, remember, so they can go back to the scanned documents and say, okay, we have this and this and this on our system, and we look at your documents that you have with you, and none of them matches the documentation that we have on our system. Okay, that's red alert. So they may tell you, okay, we are detaining you for A and B reasons. And therefore, if that is the case, then it means that they are possibly looking at ways by which they can send you back to your country of origin, because the information or the document presented to them is looking very different from the information or the documents you presented to them at the time of the application. So it's possible that they can detain you, even though it's not a mandatory reason for refusal. But where deception comes to play, they can say that they are refusing you entry, and they can also say that they are returning you back to your country of origin. And so it's very important that when you are in such a situation, that you do not give contrary information. If you don't know, it's better to say that you don't know, or you would like your legal representative to be with you whilst you go through questioning, because at the end of the day, you'd rather be on the safer side rather than on the negative side, where they will have ample evidence to say that yes, they have enough evidence to say that everything you said within your application is false, and therefore they have every cause to send you back to your country where you come from.
So, Laura
Yeah.
Eunice, don't you think the solution to this problem is to have a copy of all information provided on your application with you at all times when you travel? And is it allowed when you are being asked those questions, you keep on referring to, your copies with you in your bag? The second thing too is there are some people who are very timid, even though they know, the questions, whatever they put on their application, they are very timid and honestly will be fumbling here and there, which is not their fault. So is there any way they could make it clear to the entrance clearance officer that I'm very timid? So if possible, maybe they might have someone who speaks the local dialect to, ask those questions. Is there any way? Because I just want to I want to know what is the solution. Do you keep copies with you? And also make it clear to them, especially if you are very timid and therefore will be fumbling, giving you wrong answers.
Yeah, I see where you're coming from in terms of somebody who is very timid and shy. Of course, when you come before the border force officer, so I was explaining that there are three parts to the Home Office. So there's the border force, there's the UKVI, and then there's the defense department within the Home Office. So the border force are people within the airports and the ports, which are the seaports and other ports where people may enter. And so the border force, their job is to make sure that the people coming in are with the right status and they're coming in for the right reasons. And so if you come before a border force officer and they are questioning you and you think that you're not in the best frame of mind to be questioned, let them know that you've been on a long journey. You are tired, you are exhausted, you just want to go home. And you are not in the mood to answer any questions. You would want your legal representative here. And they will schedule another date for another
But they will allow you entry.
If they have your details, definitely. And in some cases, they usually retain the passport of the person. Yes. So in such cases, they will retain your passport and then they will allow you to leave. And in such cases, it means that they will give you a note to let you know that you're on temporary bail. So you don't have leave, but you are being given temporary bail to be able to re-attend an interview at their premises where they can question you further to determine whether to cancel your leave or to allow you to continue to remain.
Okay, I think that is better. At least a little bit of fresh air, feel more relaxed, then come back again or with your legal representative, to take you through the questioning. And my concern as well to this is some people might also take advantage
of course,
as a reason to just buy more time.
Yes. Sometimes it's good to also use what is available to you. If you need time to go and refresh your mind as to what is there, then yes, they may keep you for a number of hours, but to them, they're only doing that to frustrate you and to make you feel like they have something against you. But more so, I think that if you let them know that you're tired, you're in need of some rest, you want to come back another day and
Right.
have that interview done,
Mm.
they should allow you to.
Okay.
Regardless of how long they keep you there, they will
Yeah.
allow you to
Okay.
go away on temporary bail, because they will have your information and your details
Mm.
readily available to them as well. Yes.
Okay. But
Yes.
Eunice, is that, are you done yet with what you
Yes.
were
Yes.
explaining? Right. So another thing I want to ask is that in all these instances, is there any grounds of appeal? Should they make a decision that they are not convinced with the information you've given them, and therefore you have to return? Is there any grounds of appeal?
So usually, I would say no, unless.
Wow.
So yes, when our Immigration Act of 2014 came into play, it amended the rights of appeal that most people have. So if you are looking clearly at somebody who has a right of appeal, that will be somebody who has a human rights basis or claim. So
Mm-hmm.
if you are saying that, yes, I made an application to come and join, let's say, my family member who is my spouse here in the UK,
Yeah.
and they're saying to you that we are not going to allow you entry to come into the UK, they have to grant you a right of appeal because they are refusing you entry into the UK.
Right.
Or if it's based on humanitarian protection, usually in cases like that, so asylum and humanitarian protection, you will have a right of appeal in cases where you are coming to join a family member on that basis as well.
Mm-hmm.
And then we have those that are deprived of their British citizenship who are also given a right of appeal. And the last but not the least, which is outside of our Nationality and Immigration and Asylum Act, is those that are EU nationals and can say that they are joining or coming here to join their EU or EEA national family member.
Family
So
member.
these categories of people will have a right of appeal, and they can obviously appeal any decision. Apart from
Okay.
that, any other application route is without a right of
Right
appeal.
of appeal. Okay.
Yes,
All right.
yes.
Great. Okay. So I've got a question here from Irama. She says, "Good afternoon, Vicky and Lawyer Eunice. I'm really enjoying your show. Keep the good work up. Thank you." She said, "I have a brother who came on a visit and was detained at the airport. We were not able to get proper legal assistance, and he was taken back to Ghana. He was given a letter that his leave had been cancelled, and this could lead to a 10-year ban if he attempted to re-enter the UK. He wants to reapply as a skilled worker. What does he need to do, Eunice?"
So here you have it, as a person who has come and has been returned because maybe that they found something on him that did not correspond with information that they had. It may be that
Right.
he gave information which had nothing to do with his reasons for coming on visit. So it could be that for one reason or the other, this person had put in his application, maybe I'm a student, I'm coming here to sightsee 2 weeks and then go back. But then
Mm,
in his questioning, it comes out that no, he's not even a student. He works for a shipping company, and obviously because the shipping company has given him holidays, he's coming here to work. This is completely contradictory to what this person may have put in their application. Obviously, I don't know what the circumstances of this particular person is,
mm,
but we're going to pay attention to the fact that they have said to him, "We have refused you entry into the UK, but do make sure that when you are returning, that you have reasons put down. Otherwise, we may obviously put a 10-year ban on your re-entering into the UK.
Okay.
So somebody like this has left the UK as he or she was told to do so, and it's now apparent that a lot of people are applying onto the health and care route, especially because it's an area that there is a lot of demand. Where a person has previously been removed, so this is not somebody who has been deported. So there's a
Right.
difference between a person who has been removed and a person who has been
Has been
deported.
deported.
A person who has been removed is usually removed because maybe they've breached some immigration rules, and therefore the border force have seen it fit to take this person on the next flight back to their country. A
Yeah.
person who has been deported is somebody who has committed a criminal offense for which they have been given a prison sentence of at least 12 months or more. So, in such a case, where the person has been convicted of a prisonable offense, and that person has been given at least 12 months in prison, that person is likely to be deported if they are a foreign criminal. So
Mm.
if they know that after your conviction they don't want you in their country, the law allows them to give you that deportation order, and therefore you will be deported out of the UK. So there's a difference between deportation and removal. And
Right.
usually most people who are deported have a 10-year ban,
Fine.
sometimes even 15-year ban, depending on the offense and the term of their prison offense.
Right.
So, in such cases, even if you have served your period of ban, they may still refuse or cancel your entry. But when it comes to somebody who is being removed, usually the case is that we don't want you here because of so and so reason, and therefore you should not enter our country again until a period of 2 years has passed.
Right.
Especially if they paid for the expense to
Okay.
send you out of the UK, then usually a 2-year ban will apply.
Mm.
Where this person comes in is where they have said that they may apply a 10-year ban. So it means that they used deception, or they do suspect that this person used deception. And usually, where there is a case of deception, where they feel that information should have been disclosed that was not disclosed, or information was given that was not provided on the application, and therefore they have every reason to say that deception was used, or even documentation was provided that was not provided as part of the application, then they would say that a 10-year ban is likely to apply if re-entering into the UK. And it is for you
Mm.
to rebut that suspicion of deception. If you know that when you were making your application, you gave the lawyer or the representative all the documentation that was needed for the application, and
Mm.
therefore, if there was anything on the application that was not correct, you need to present all of that information to them. And so, if they're saying that you provided bank statements that were false, for instance, you have to go back to the bank and say, I had this statement issued by yourselves from so and so date to so and so date. Can you now confirm that these bank statements are from the bank and not something that are forged or is not a fraudulent document? Go back to the
Mm.
bank, let them give you some supporting evidence or letter to go with it. If it is a birth certificate, for instance, yes, go back to the registry where the birth
Mm.
certificate was granted. Ask them for a confirmation letter that you want them to confirm that this birth certificate was issued by themselves.
Okay.
It's always good to have these things done so that they don't have any legs to stand on when they say
Exactly.
that information you provided was false. when you know clearly that this is the information that you presented to them, and therefore, if, for instance, there was even a mistake on the application, they should see it as a mistake because the documentations that you have now presented show that there was no form of deception intended. And for instance, with visitors applications, a lot of the time people don't realize that they are asking, have you ever traveled to the UK before? And some people will put no. Or have you ever stayed longer than you should have? Some people just say no, 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 no to everything. And
Everything.
unfortunately, it is not the case. So we need to be very careful in the way that we answer the application questions. It may be that something as little as you taking yes and then you said no. And because you said yes,
Oh,
no, that can be an issue. And therefore, they will say that you use deception. Hence,
really?
yes, yes.
So can't one make a mistake?
And that's why it's very important that when you are making a subsequent application, you provide as much evidence as possible to obviously interact or counteract their argument that the information that you gave was false.
Oh,
So
right.
yes, you may have said yes to something when you should have said no, or you may have said no to something when you should have said yes. And if you know that it was a typographical error or something that
Mm,
was not meant,
mm,
as soon as it comes to their attention that this is what was stated, provide as much information to say that you did not intend to answer
right. Okay.
no. Yes, and this is the evidence you are providing to show that, yes, this is what happened. And you did not in any means or way try to deceive them, but you just obviously made a mistake by typing no. And this is the evidence that you are presenting to show that, yes, I made a mistake. This is the evidence that I'm putting forward. It was never your intention to deceive, knowingly deceive them in any way or form. And there are case laws to obviously back you up when you're talking about
Okay.
deception and whether deception was intentional, and if you acted in accordance with the evidence that was given and whether it was a mistake. And if it is seen that it was a mistake rather than something that was done intentionally, then obviously they shouldn't perceive it as being an intention to deceive, but that obviously you misrepresented information that should have been given to them. And so that's where the discretion comes in. They may
Okay.
believe the facts and the documents that you presented, and they may say, okay, we don't think a 10-year ban should be applicable. And they may say that, do you know what, we don't still believe your story, and
Mm,
therefore a 10-year ban will be applicable. Sometimes it can be very harsh, very,
mm,
very harsh, but
mm.
unfortunately, that is what it is. Uh,
Okay.
is.
Right. I realize time is fast spent, so let me take one more question, then we'll round up. I've have another question here, but the person wants to remain anonymous. She says, I came as a student in January 2022. My husband arrived in the UK in March 2023. However, it was said that the bank statements in his bag did not match those he provided during his application. Therefore, the statements he provided to support his application were false. The officers phoned me whilst at the airport to ask a few questions, which I confirmed. He was later released and asked to come in again for questioning in 3 weeks' time. What can he do to stop them detaining him?
Okay. So in a situation like this is somebody who has come to join his wife here in the UK. And
Mm,
he obviously has been given temporary bail. So I was saying that temporary bail is when they allow you to go. They may retain your passport, but they allow you to go, and then they tell you to come back again because they want to make a decision as to
Yeah.
whether to cancel your leave or to obviously grant your leave back to you. So in such a situation, because you have temporary bill and you haven't really got leave to remain in the UK,
Yeah.
there's a likelihood that they can send you back to your country of origin. If
Mm.
it's the case that he is here with his wife and maybe they also have a child here, I would say to this person, please make a human rights application, because
Right.
any any application that's not a human rights application does not allow for a right of appeal, and therefore once they've made their decision, they can easily say to you, hey, we don't want you in our country, can you
Okay.
leave? So
Okay.
if it's the case that you are here with your spouse or you have a child here in the UK, make a human rights application whilst on temporary bail.
Right.
That could also help in terms of them detaining you. So if, for instance, you've made that application and you went for re-questioning and they saw that, okay, the information still doesn't tally, we want to detain this person, then the legal representative can make an application for bail based on your human rights and say that this is somebody who has family life and therefore should be given bail and therefore should also remain here with his family members. If
Mm.
it is the case that, of course, you are looking to see how best you need help, then please, maybe you need to go to a solicitor for them to coach you in terms of likely questions that you may get and how best to prepare yourself. So
Mm.
it may be that it's not just the questions you have on your application, it may be general questions to do with you and your spouse. And they just want to know that you have all of those things intact. So, as much as
Okay.
possible, if you are in such a situation and similar to this person, you have a spouse here,
Mm-hmm.
put in a spousal application, put in a human rights application. That could save you a whole lot. Yeah.
Okay. All right. All right. On that note, we've come to the end of the show. Yes, 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 yes. And before Lawyer Eunice, give us details for people to contact her. She's going to just give us a brief of what we've discussed so far for the benefit of those who just joined us, during the latter part of the show. And she will later leave her details for anyone to get in touch with, her and her team. So, Lawyer Eunice.
Yes. So when it comes to what we've been discussing today, I know a lot of us may know somebody who is in this predicament or may have known somebody in that predicament and may have family members who are coming to join us from outside the UK. And if you are such a person, then I would say that it's important to have information readily at hand. You don't want to be in a situation where you are interrogated at the airport and you have no clue whatsoever what was on the application. So, in terms of preparing yourself, make sure that you have every information that was placed on the application. If it means getting a copy of the application and then going through the information that was put on there, please do so. Depending on the application that was made, you will know what information needs to be answered. And so, if it's to do with a family member, you know that you have to know that family member through and through. If it's to do with a skilled worker visa, you know that the role that you've said you've come to take part in, you are coming there to take part in that role, and therefore the company you are working for is looking for people with such and such skills so that you can work in that area. Or it could be that you are coming here even as a student, and therefore you should have every information available to you in terms of documentations that were presented as well. So even if you don't have a copy of the documentations presented, you should know what information was presented. So if you're saying that my wife was the one that gave her documentation, yes, your wife gave documentation in terms of your application, but you should still know what bank she's using and the information that was used. So if it was bank statement presented from January to March, then you know it was bank statements presented from January to March from Fidelity Bank, for instance. So you should have an idea as to the information that was presented, copy or copies of the documentations that were also presented, just in case, obviously, it becomes necessary. I mean, there have been situations where people's phones have also been taken just to verify information on there. If the information on there is also not tallying with the information they have on the application, then you may be found wanting. So I would say it's best not to even travel with a phone at all, just in case it gets found out. Because some people think that as long as it's in my 23 kilo luggage, they wouldn't find it. Of course, all these suitcases are scanned, so they know where to pick the information from exactly and how to get the information. So, as much as possible, they will ask your permission, and you can say to them, maybe my phone is locked, I'm not willing to grant you access into the phone, and therefore, whatever they are looking for, they should ask you as well. So, yes, when it comes to situations like this, don't panic. As long as you have the information, you can go ahead with it. But if you feel that you are tired, if you feel that you are not in the right frame of mind to go ahead with interrogation, do let them know. They will give you some time, they will tell you to relax, to chill. And if they come back and you still are not in the right frame of mind, just let them know that you are still not in the right frame of mind. You want your legal representative here with you, or other family member here with you before you go ahead with any questioning. But as much as possible, do not give them an upper hand by having contrary information, which is different to that which was presented at the time of your application. Yes, it's just a quick summary, but if you are in any situation like that whatsoever, do seek legal advice, do seek legal support, and we will try and help you as much as possible if you are in a situation where you are detained. As we said, most applications may not have a right of appeal, so it will be down to the Home Office discretion whether to detain such a person and whether to remove them. But if it's the case that you are saying that this person has a human rights basis or a right to family life here in the UK, then it may be possible to say that you are applying for bail for this person so that they can continue to remain here whilst a decision is being taken by the border force. So, yes, um, we will leave it here for this week, and hopefully next month we'll be able to see each other again, and also uh, have a proper discussion, interactive discussion with our viewers and those watching us.
Yes. So, Laura Eunice, your address and telephone number, please.
Okay, so in terms of VWS solicitors, we do not only deal with immigration law. As Vicky said, we also deal with family law, we deal with issues to do with social issues. And then also, our principal is very keen on Ghanaian law and practice because he's a barrister in Ghana as well. And he also now practices wills and probate. So if you are looking to have a will drafted, I know that a lot of us think of wills and we are thinking, oh, we are not dying yet, so we don't need to make wills. It is not only for those that are about to die. I think that when you think about wills, it is just to say that you love your loved ones and you cherish them and you want to put something aside for them. So wills are usually done just so that you can put something aside for those family members. You never know when anything will happen, so it's always best to put a will aside so that when unexpected situations do occur, you have something that you've already put aside. We are situated in London. We are on the 4th floor of the Anna House. The address is 214 to 218 Tottenham High Road, and the postcode is N15 4NP. So N15 4NP. Our offices are open from Monday to Friday from 9:30 a.m. to 6 p.m. And our office telephone number is 0208 493 7340. So 0208 493 7340. And my number out of office hours is 075 35 81 3910. So 075 35 81 3910.
Thank you, Lawyer Eunice. I would like to quickly give a shout out to Mike Apreku and Isaac Amoako. We really appreciate, your commitment to pushing this program as well, watching it every time we come on. Ladies and gentlemen, if you joined us at the latter part of this program, we have a recorded version on our YouTube channel at BWF Solicitors. You can watch from the beginning, and if there's anything you are not clear with and need advice from Lawyer Eunice, she's given us her contact details, her office address, and phone number for you to contact her. So on that note, we would like to wish you all the best. Take good care of yourself and see you next time. Stay blessed. Bye-bye.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.